So 10.06, if the case review team finds that a respondent is a sex offender requiring civil management, then the Attorney General may file a petition in Supreme Court or the county court where the respondent is located. In determining whether to file the petition, the AG has to consider all this information about continuing supervision, what he's going to be subject to, and take the supervision into account when assessing the need for further management. If they decide to file it, they have to serve a copy on the respondent. The petition shall contain a statement or statements alleging facts of an evidentiary character tending to support the allegation that the respondent is a sex offender requiring civil management. So the soft 30-day rule, Attorney General shall seek to file a petition within 30 days, dirty 30, after receiving notice of the case review team's finding. Failure to do so does not affect the validity of the petition. Okay. Within 10 days after the petition is filed, the respondent may file in the same court a notice. So this is not a motion for removal. It is a notice of removal to the county where he was convicted in or charged in. The Attorney General may, in the court where the petition is pending, move for a retention of venue. Such motion shall be made within 5 days after the Attorney General is served with a notice of removal, which time may be extended for good cause shown. The court shall grant the motion if the Attorney General shows good cause for such retention. So the court shall grant it if there's good cause. And I'm not sure why they wouldn't be able to find good cause. If the notice is not filed, it stays where it is. So if the notice of removal is not filed, it stays where it is. The sex offender, he files a notice of removal. It's not a motion. The Attorney General is the one that has to file a motion for retention of venue. Promptly upon the filing of a sex offender's civil management petition, the court shall appoint counsel when the person is indigent. The court shall appoint the mental hygiene legal service if possible. In the event that the court determines that the mental hygiene legal service cannot accept an appointment, they appoint 18B. I'm not going crazy with this section because I don't think the question is going to come out of here. I think it's going to come out of the trial section, which is in 10.07. But anyway, within 30 days after the petition is filed or such a longer period as to which the respondent may consent, the Supreme Court or county court before which petition is pending shall conduct a hearing whether there's probable cause. So if the person was about to get out, or they were going to get out, they got to have the hearing no later than 72 hours from the date of respondent's return. So they basically bring him back in. And if it doesn't happen within 72 hours, it doesn't affect the validity of the hearing or the determination. And he still doesn't get released. So it's just like a suggestion there. Again, at the conclusion of the hearing, the court determines whether there's probable cause. Court shall. Now, what does the court shall do? Shall issue an order dismissing the petition, and the release shall be in accordance with the applicable provisions of law. Again, that's if there's not probable cause. Okay, if there is probable cause, the court shall order that the respondent be committed to a secure treatment facility designated by the commissioner for care, treatment, and control upon his or her release. Provided, however, that a respondent who otherwise would be required to be transferred to a secure facility may, upon written consent to remain in regular prison. Consent may be revoked in writing at any time. And the court shall set a date for trial in accordance with sub A, and the respondent shall not be released pending the completion of the trial. So the court shall do these things. First, they have to decide where he's going to get put. Then they got to set a date for the trial. He's not going to be released. It's not really what the court shall do. Now, if the person is transferred to a secure treatment facility and they have not reached their determinant max and they're significantly disruptive, the person in charge of the programs may initiate a proceeding to obtain an order that respondent be transferred back to prison. Such a proceeding shall be initiated by a written notice written notice served upon the respondent and provided by mail to his counsel or by email or fax, provided that the counsel has an email or fax number in their that the director or whoever this person is, the person in charge of the secure treatment place, has the attorney's email address. Okay, the notice shall identify in detail the dates, times, and nature of the misconduct, the possible sanctions, the date, time, and location of the hearing. A hearing has to be held no less than 10 nor more than 60 days after notice is served. Again, it is measured from the notice is served. The hearing shall be held no less than 10 nor more than 60. The hearing shall be conducted by the director at the secure treatment facility or by his or her designee. The respondent may have counsel. Evidence is introduced through witnesses and documents. Respondent may call and examine and cross-examine witnesses and present documentary evidence relevant to the question of whether he's been significantly disruptive of the treatment program. The presiding officer may accept evidence without applying state or federal rules of evidence. The hearing shall be recorded, or a stenographic record of the proceedings shall be kept. When the hearing the matter, and if allegations are sustained, and if allegations are sustained, the presiding officer shall consider the respondent's mental health and its effect, if any, on his or her conduct. At the conclusion of the hearing, if the presiding officer is satisfied by a preponderance of the evidence that respondent was significantly disruptive at the secure facility, the presiding officer shall so find. In such event, the presiding officer, not the court, it's the presiding officer, may order transfer back to the prison for a period of up to 6 months. Provided, however, that when they reach their maximum term of the underlying sentence, they have to be returned to the secure treatment facility unless they consent in writing to stay in regular prison. At the conclusion of the hearing, the presiding officer shall prepare a written statement to be made available to the respondent and his or her counsel, indicating the evidence relied on, the reasons for determination, and specifying the procedures and the time frame for administrative appeal to the commissioner. So this appeal is not to a court. It is to the commissioner. The determination appealed is provided by writing to the respondent. They get 10 days after notice of determination at least. And the transcript or the recording has been provided to perfect the appeal. So once they get the transcript, they have to have at least 10 days after that to perfect the appeal. The respondent may be represented by counsel on the administrative appeal. So that is what I have for 1006. 1007 I started already, but I'm going to resume with it. God. Oh my God, this video is already 9 minutes and 7 seconds. All right, maybe we'll come back to 1007. Okay, so mental hygiene law 10.07 continued. Within 60 days after the court determines pursuant to sub K 10.06 that there is probable cause to believe the respondent requires civil management, the court shall conduct a jury trial to determine whether the respondent is a detained sex offender who suffers from a mental abnormality. So the number one question the jury is deciding here is an issue of fact, and it's whether or not the respondent is a detained sex offender who suffers from a mental abnormality. Now, this is where it gets a little bit confusing. It says the provisions of Article 41 of the CPLR shall apply to the formation and conduct of the jury trial. Okay, except that provisions of the following CPL sections govern to the extent that they are not inconsistent therewith. Now, Section 270.05 is the first one. The very first line of 270.05 is that there are 12 jurors. 270.10 describes a challenge to the panel. 270.15 is voir dire generally. It begins with saying that the names of not less than 12 jurors shall be selected and seated in the jury box. 270.20 describes the challenge for cause. Subdivision 1 of 270.25 is just the definition of a peremptory challenge. And then 270.35 is about replacing a juror, and it says that the respondent doesn't have to consent in this section because it says, except for the provision requiring consent of the replacement of a discharged juror with an alternate. So, each side shall have 10 peremptory challenges for the regular jurors and 2 for each alternate to be selected. The right to jury trial may be waived, and upon such waiver, the court will have a non-jury trial. All right? So basically, that is what this is saying. So even though it does say the CPLR, the provisions of those rules apply to the formation and conduct of a jury trial under this section, the provisions of CPL 270.05, 10, 15, 20, sub 1 of 270.25, and sub 1 of 270.35 apply, and that is specifically talking about the number of jurors.